Over the years, many North Carolina laws and rules have added to the list of activities deemed to be crimes in North Carolina. Things have gotten so convoluted that the John Locke Foundation is now working to help provide lawmakers with knowledge and the best way to modernize what's known as the criminal code to make it more clear, more efficient, and more fair. This reform effort recently took a pretty big step forward. And the John Locke Foundation's legal fellow, Mike Schietzelt, is here to help us understand what is happening. Mike, welcome back to the show.
Thank you.
First of all, when we say criminal code, what are we talking about here?
Right, we're talking about everything that's a crime in North Carolina. So the general statutes, the common law, the code of ordinances for each town and city and county, and any administrative rules.
So not just say murder, robbery, anything like that.
Anything from murder or robbery to your local ordinances against maybe panhandling or letting your lawn grow too tall is one we've talked about a lot.
It appears that what's happened is that over the many decades, everybody has just kind of piled on, whether it's your local city council or the state legislature, and for one reason or another, they've decided that certain things are a crime, and it's all kind of buried in mountains of paperwork. And you are here saying, hey, wait a second, we need to figure out where everything is, where it exists, and what makes sense and what doesn't.
Right. They started with the common law when we were a colony. It was the common law. The legislature kind of took on the onus of adding to the common law for a while. And then in the late 19th century, they delegated it out to local governments as well. And of course, with the administrative state has risen up, they've delegated that authority also to administrative agencies. So it's just kind of a problem of how much we've delegated, how little oversight there is over all of this, and it's just grown unchecked. A colleague just used the word metastasized this morning about it, and I think that's a good way to describe it.
And in a lot of cases, as you have written about this at johnlocke.org, people can run afoul of the law, have no idea that they have technically committed a crime in North Carolina until someone calls them on it, and they end up trying to fight some sort of legal battle, and they just don't even know it. So because of all of that, you have really taken on this effort to try to help lawmakers understand where everything is. And they've taken some very interesting and positive steps forward. First of all, tell us about what is already in place, which is called, and this is a mouthful, the Criminal Law Recodification Working Group. What does that really mean, Mike?
Right. So the Recodification Working Group was never actually a formalized group that was put into the bill. It was in the title of the bill, but there was a group of people from the Administrative Office of the Courts, from law enforcement, legislators who were interested in tackling this problem, also from the academic community and the policy community. So we've gotten a group together that had been working on these issues, kind of discussing where this needed to go. And the first thing was, we need to get this information in. We don't know exactly where to start until we have all the information in front of us about what is criminal. So that bill, the Recodification Working Group bill, asked cities, counties, municipal sewerage districts, and administrative agencies for this information. What is criminal in your jurisdiction? What crimes have you defined?
Now, this legislative session, there has been a step forward here that you've written about, and three different things in particular are going to occur that you say and you write about are really going to benefit North Carolinians. Let's talk about those. First of all, you write about an incentive for local governments to actually submit reports on all this.
Right. So the response rate to the first request, the working group bill, was low. And probably part of the reason for that is, well, A, it's cumbersome, but B, there was nothing, there was no carrot and no stick, right? They didn't have any incentive to respond to this. What this bill does is it kind of creates the incentive. If local governments of above a certain population threshold don't respond, then their ability to create new crimes or define new crimes within their jurisdiction is frozen for a period of 2 years while the General Assembly gets the information it needs from their code of ordinances. So that's an important step forward now. Hopefully we'll have a higher response rate, and with a higher response rate, more accurate information to move forward with.
You also write about something called automatic legislative review. Help us understand what that is and how that's going to help.
Right. So that's more oriented toward the agencies. So administrative agencies, they pass rules. These rules define criminal conduct. Usually the legislature will have delegated that authority to them, saying any rule promulgated under this article, the violation of any rule promulgated under this article will carry a Class 2 misdemeanor, something like that. So now whenever an agency passes a rule like that, the rule will automatically have to be reviewed by the General Assembly through their rules review process. So the General Assembly can essentially veto it and say, listen, we'll allow civil penalties for this crime, but we're not going to allow it or we're not going to allow the agency, we're not going to allow law enforcement to impose a criminal penalty for this violation.
Mike, was there pushback from local governments as this was all being debated?
There was. There was quite a bit of pushback. The earlier versions of this bill were a bit more ambitious and wanted to put an end to the practice of automatically criminalizing local ordinances or most local ordinances. And then also to put a sunset on the local ordinances that were already criminal. There was, understandably, I think, a lot of pushback. The bill hit a lot of headwinds in that process.
Nobody wants to give up power. That's just human
Nobody wants to give up
nature.
power.
And as soon as somebody else comes along and says, hey, you're not going to be able to do this, you've got to stop that, naturally, the hackles come up.
Right. And, of course, law enforcement relies on this as an enforcement mechanism. If somebody doesn't have property, or for example, civil penalties aren't going to be quite as effective in enforcing the law because there's no property to attach the civil penalty to. We can't say, pay us the $250 or we will seize your car or something like that. So it gets kind of hard when you're enforcing a noise ordinance against a college student who doesn't have any property in the area.
Right.
So there was a lot of understandable pushback from the groups representing local governments. And we've gotten a lot of positive feedback on that I think will help us move forward in this process more effectively.
Mike, as I've been reading your writings on this, and all of this, of course, is available at johnlocke.org, it's been amazing to me to learn about the fact that things are so different from city to county, across the state, from regions, because you have local governing boards who are going about their business and they are enacting these things. And then, counties that are 3 or 4 counties away may be doing something completely different. That leads me to the next item that you write about that you say is so important in this new legislation, and that is consistency statewide.
Right. Uniformity is a goal that we should strive for with the criminal law in particular, because again, you're talking about the state's ability to seize your life, liberty, or property. And so there needs to be, to the extent possible, uniformity in the rules across the state. Now, practically, it's kind of hard to make that a reality, but to the extent possible, it's what we should strive for.